right?
Yeah, the July meeting of the Compensation Council is called to order. A lot of you know that the July meeting of the Compensation Council marks the end of high summer and the start of fall. Back today, it's beginning to go down and soon there'll be lots of snow on the ground. But in the meantime, we are here and we have a very full agenda. And the first thing I would like to note is that we have 3 new appointments. So why don't we go through and any of those who are here would like to introduce themselves? Benson, why don't we start with you?
Yeah, hi, I'm Ben Whitney. I'm, as Chair said, a rookie in this matter. And even more so, I only got the notice like day before yesterday, so surprised I was able to come. Any event, yeah, I'm currently retired, but I've been an attorney and a business school dean and a few other things in my life, and I look forward to working with you in the council.
And Benson is a Supreme Court appointee. Betsy O'Berry. Hi, Betsy.
Hi, my name is Betsy O'Berry. I am also a Supreme Court appointee. I am a certified public accountant with over 40 years of experience. And I live in the 6th Congressional District, so I think you may be looking for some geographic diversity here.
And Adam Hansen.
Yeah, hi everyone. Adam Hansen. I lead technology teams at US Bank. I'm a House appointee and I live in Brooklyn.
Thank you. Welcome aboard to the Compensation Council. We are now going to have approval of minutes. I just put a tape, we have a quorum, and we're now looking at the minutes. And I would entertain a motion.
Approval of the minutes for the June 18th, 2026 meeting.
Second.
Motion has been made and seconded. Discussion? No discussion. All in favor, say aye.
Aye.
Opposed? Minutes are adopted. First up today, we have a presentation of the Judicial Selection Commission. Our presenter is Erin Sinberg Porter. Erin?
Good afternoon.
I'm setting yourself up to the table and we will begin.
It's nothing elaborate, so it won't take very much time. I move this slightly. Good afternoon. Thank you all for having me here to address you again. I appreciate the opportunity. I am appearing today in my capacity as chair of the Commission on Judicial Selection. Many of you are familiar with the work of the commission, which is constituted by statute, by state statute. We have 49 members, 9 of which are at large and serve on each vacancy, judicial vacancy at the district court level throughout the state. And then we have 4 district members in each of our 10 judicial districts, which do not align for some reason with our congressional districts. So I'm here in that capacity. These are my, personal perspectives and opinions that I want to share. 2025 was another very busy year for our commission. The governor made a total of 21 appointments to the judicial branch, which are 9 district court and 2 court of appeals vacancies. For district court vacancies, the commission reviewed 173 judicial applications, interviewed 97 candidates, and forwarded 51 finalists to the governor. The at-large members also served on a merit selection panel for the 2 vacancies on the Court of Appeals, where the panel reviewed 28 applications, interviewed 11 candidates, and forwarded 4 finalists to the governor. In 2025, the commission received and considered applications for vacancies in all 10 of the judicial districts in Minnesota. On average, the number of applicants per round is as follows. In the 1st judicial district, 13. In the 2nd, 19. In the 3rd, 9. In the 4th, 35. In the 5th, 6. In the 7th, 8. In the 8th, 5. In the 9th, 6. And in the 10th, 15. So put another way, in metro vacancies, the commission received on average 21 applications. So metro is Ramsey, Hennepin, surrounding counties like Hennepin, or excuse me, Anoka, Washington, Dakota, et cetera, and 9 applications for vacancies in Greater Minnesota. Over the last few years, Minnesota's judicial salaries have dropped when ranked nationally. Last year, Minnesota's judicial salaries, depending on the level of the court, ranked from 23rd to 27th in the nation. As a point of personal pride, I will say that I am tremendously proud of the work of the commission, and I'm very, very proud of the bench that we have in Minnesota. And I would submit to this body that when considering the quality of judges that we have on the bench, that ranking of salaries is not commensurate with the quality of our jurists. Currently, judicial salaries in Minnesota range from $117, excuse me, so $190.17 for district court judges to $236,429 for the Chief Justice of the Minnesota Supreme Court. These salary levels have remained unchanged for 2 years, resulting in Minnesota judicial salaries falling between $2,918 and $7,995 below the national average. To address this, I propose the following salary increases at a minimum to remain consistent with the national average and to ensure that we are able to recruit attorneys from all backgrounds to the bench. District Court Judge, my proposal would be $200,000. For Court of Appeals Judge, $225,000. For a Supreme Court Associate Justice, $250,000, and for the Supreme Court Chief Justice, $277,000. These proposed increases would make Minnesota's judicial branch salaries commensurate with states across the nation and more in line with federal judicial salaries in the local legal market. I want to speak briefly to recruiting. It's not easy to identify exactly how many attorneys might find compensation to be a hurdle or an obstacle to seeking appointment on the bench, but it is a factor that is consistently cited by prospective applicants as a reason for not seeking judicial appointment. Looking at the legal market salary trends in Minnesota, the starting salaries for first-year associates at large metro law firms range from $190,000 to $225,000 per year, and increase significantly over the course of careers. On average, judges appointed by Governor Walz in the metro had around 15 years of experience prior to their appointment, which means that appointees are taking substantial pay cuts. The commission strives to advance candidates from a wide variety of backgrounds. We are very concerned with making sure that there is a diversity of professional experiences on our benches. But the financial compensation for state court judges compared to what someone can earn elsewhere, particularly in private practice, can make it very challenging to recruit interested applicants. You'll receive these written remarks, and included in that will be practice backgrounds of judicial candidates and information on judicial salaries. I also have the list of questions that were posed to me last year. I can address those if that's of interest. So one question that I received last year was whether we had a sense of the distribution of lawyers in Greater Minnesota versus the metro. As the numbers that I read reflect, it is not uncommon for us to receive many more applications in the metro area as compared to Greater Minnesota. And part of that is just because there are fewer attorneys in Greater Minnesota. Population is a challenge for us there. We are in the process of receiving this specific data from the Supreme Court. And the answer to the question of whether that distribution of lawyers has an impact on the numbers is obviously yes. That I think feeds into a second question that I received last year, which was whether the judicial system should look at allowing applicants to establish residency after acquiring a judgeship. So after appointment, this is a question that we get quite often. People tell us that they would move if they knew that they were going to be appointed. I think that that's a matter of policy and best left to policymakers. but I think it could help. And I think it would also be something that needs to be considered carefully, because in our experience, a lot of our stakeholders have a great deal of concern with whether candidates have sufficient familiarity with the courts that they are seeking appointment to. So sometimes it's good to have someone from outside that judicial district or outside that area. Sometimes it's important to get that external viewpoint, but that is something that we often hear, is some concern with familiarity with the court. There was a question about the clarification of our judicial districts. And I think really an observation that Hennepin and Ramsey are each their own district. But then the remaining 8 are multi-county. That is a true statement. It is just a reflection really of the population in all of those places and the composition of Hennepin and Ramsey respectively. I've provided recommendations, which I think was a specific question I received last year. So again, you'll have those written materials. I received a question last year about how perhaps appropriate it would be for Minnesota judicial salaries to get closer to federal judicial salaries. I don't really have a strong opinion on that. I think that we can center the analysis in looking at what other states pay, and it is certainly true that other states, such as I think Illinois, Washington, and Hawaii, all have a much closer tie to federal judicial salaries. In other words, those salaries are closer together than ours here in Minnesota. I received a question about the quality of candidates last year and whether I thought that the quality of candidates is competitive. I would answer that question in fact in lawyerly fashion that it depends. So we work very, very hard on recruitment, and part of the reason that I've driven here today to talk to you all is because I'm committed to ensuring that the commission can continue to recruit long after me in its next composition, and to make sure that the highest quality candidates are putting themselves forward for this service. It is a very demanding, difficult job. It is incredibly important to the people of Minnesota. And one way that we can help ensure that more attorneys who are qualified to be judges are applying is to make sure that the salary is commensurate with the responsibilities, treated appropriately, excuse me. I think those are the only questions that I received last year that I have not already answered. I'm certainly happy to answer any other questions if you have them.
Questions from the room?
Hi, my name is Susan Holden. I'm a lawyer that practices in Minneapolis, and have been in the practice 40 years. Been a lot of changes over that time period in terms of the numbers of applicants, both in Metro and in Greater Minnesota, for judgeships. Yeah, now as you highlighted, it's evidently number in 4 areas. You piqued my interest by your comment about opening up perhaps, you know, the applicants to beyond the judicial district. Do you have any research or anecdotal information or an opinion you formed on your own about how that might solve our issues in Greater Minnesota?
I do have an opinion. My husband would say I have one about everything. We have such tremendous embarrassment of riches in our applicants in the metro. And we are able to draw from a rich cross-section of professional backgrounds, right? We have public defenders, we have federal prosecutors, we have federal defenders, we have lawyers in private practice. I mean, we have kind of the full mix that you would want in many of our application pools in Hennepin and Ramsey County. And we have some people who, if they were in another pool of candidates in a different district, might fare better and might be able to be appointed, but haven't been able to kind of break through because the competition is just that fierce in the metro. So my opinion is that removing that residency barrier could be a solution. But as I said, I think it has to be treated with the appropriate stakeholder engagement because things are different, as you know well, in different courthouses around the state. And we do have to make sure that our candidates understand the work of being a judge, but also the work of being a judge in the particular courthouse where they seek to serve. And so I think it's really important that if that barrier were to be removed, or if there was some legislative solution, I think it's very important that it is not perceived as the metro kind of exporting talent to other parts of the state, but is looked more at a holistic solution to even up distribution, if that makes sense.
Well, I think it's a reality that there are fewer lawyers practicing in greater Minnesota than ever. I'm familiar with the State Bar Association's numbers in that regard with respect to their membership. Now, it's not a 1-for-1 because Minnesota State Bar is a voluntary bar, so not every lawyer joins. But it's been a pretty good measure of the years as to where lawyers are practicing. Yeah, the number of lawyers practicing in greater Minnesota has been declining for some time. And make me have slightly softened that decline. It's been a pretty steady decline.
I agree with you, and I think in that regard, it's a little bit of a bigger problem than just judges.
Or the salary identification. Thank you.
On this appointment. Debbie, yes, on this point.
I just note that the requirement that district court judges be resident in their district is a constitutional requirement. And so it would not be a statutory provision. It would be a constitutional amendment.
Yep.
So I've had a conversation with Mr. Short by email a couple of years ago. And we discussed exactly what you're doing now. Brought up a point that the senior judges routinely serve outside outside their residency. And he said, well, I just can't really get around that. And I said, well, you could establish a statute that residency is obtained at least maybe 60 days before they face the electorate. Now, I'm just going to give you one example. It's not just metro versus rural. Look at Wilkin County. It just happens that I was married when judge was the actual presiding chief judge of the district. He's in Breckenridge. Is at the edge of the district. Everything south of there is very sparse. Breckenridge is under 10,000. But to the east, you have Otterdale County, which is Lagos. A lot of older lawyers, not a lot of Moorhead. That's a 40-minute drive. If they're looking at reestablishing, those are the folks who are actually serving generally as lawyers in the Breckenridge courthouse. So that's just one example. It's probably the most extreme example if you look at the maps, but it's going to be very hard that county judgeship becomes open again. It's just going to be very hard to find someone in that district.
We're
gonna move on from this point because David and I were talking about the jurisdiction of this group and boy, this one may be a little bit up far afield for us. Go ahead, one response.
I think that with respect to Mr. Driscoll's point, that is at the time of appointment that a person is required to be resident. And so I think where there is room for discussion or perhaps solution is, can people apply if they are not resident? That's where I think there might be, but again, I know that's not for this group, that's just for the record, as we like to say.
Food for thought. Other questions?
Just a brief comment and a question. In your remarks, you properly expressed your pride in the work of the commission. I moved to Minnesota during Governor Perkins's last. And so I've had the benefit of practicing in district courts and courts of appeals and reflected the work of the commission. And I've seen the bond extended. And I agree with the judiciary that is something we should all be very proud of. So thank you for your work. The question I had relates to recruitment. And I know that everybody self-selects, so to speak. And there are things like salaries and so forth that are critical to those decisions. But is there more that we could be doing in terms of encouraging people to really focus on the judiciary as well? Whether it's through the governor's office, through the bar, or through.
I think the answer is yes, but knowing the exact right spot for the members of this council in that, I'm not sure that I have a specific response there. We always encourage members of the bar and bench to let us know or let others know that they think would be good candidates, that's what they think. In some instances, names are forwarded to us. We do the outreach and, don't let them know who has said that they would be good, and they still have to go through the process and there's due diligence and all of that. Mr. Miller, who is the Director of Judicial Appointments in the Governor's Office, and I have a roadshow that we'd be happy to give anybody in this room about the process of applying and considerations for candidates. But I think in particular, when we think about Greater Minnesota, I think the answer to your question is a resounding yes. I just don't know that I have kind of a specific plan that I could recite here as to what might be most effective. Thank you.
Gary Borgendale, my question is of the compensation of Metro judges versus outstate. Is there in process to give a cost of living raise or component for that, the living expenses in the Metro versus outstate, partly into the compensation of the Metro attorneys versus outstate and how they're under the average of the private sector?
My understanding is there's no distinction among judicial districts. I know that in certain circumstances, for example, service on the Court of Appeals can come with some stipend of some kind for judges who have to travel to serve on the Court of Appeals. I think that the delta might seem most pronounced in terms of actual numbers. I think that the problem persists equally in Greater Minnesota as it does in the Metro with private attorneys. I think that, especially in Greater Minnesota, I think those attorneys can be quite busy, given that there are fewer of them to serve in those areas. And I think that there are probably a number of trade-offs in both situations. And so I think that in some ways you give up some flexibility in addition to taking a pay cut. And I think that probably looks different if you are a Metro lawyer versus being in Greater Minnesota.
Just a follow-up question. Is that an issue relative to Metro cost of living being much higher, or is it not an issue?
I don't perceive it to be an issue, but we haven't heard that specific feedback.
Thank you.
Final questions?
You mentioned some of the challenges with recruiting, especially as it relates to private sector salaries. But are you seeing any difficulties with retention or attrition? Salaries?
Not that I'm aware of. Most people say it's the best job they've ever had.
This is the best job anybody.
Thank you all very much.
Appreciate it. Thank you for your testimony.
Yeah.
Thank you.
We'll be going back and forth today because of the timing and schedule of some of our people are gonna come testify. So we're gonna move between the OIG stuff and the judicial selection stuff. And our next testifier is going to be presentation by Travis Bunch, Minnesota Manager of Budget, talking just in general about the current forecast and budget projection. Please introduce yourself for the tape and again.
Thank you very much, Chair. Travis Bunch, I'm the Deputy State Budget Director for MMB in the Budget Division. Really happy to be here and provide a little bit of a budget overview of about 10-15 minutes worth of content to talk about. And this is all information that has been updated for end of session changes from 2026. Pretty fresh, hot off the press. We just posted our documents just a couple of days. So I want to start with talking a little bit about our biennial budget process before getting into the budget overview. Then I also have a few slides on some of the drivers of growth in the general fund. We could probably spend 2 hours talking about drivers of growth in our budget. So I just have a few slides, and then if you want more information, you can search us more time to talk about that, but it'll give you a flavor of what's really driving the increases in spending in our general. So just quickly about the biennial budget process. This is a little bit of a flow chart. What the takeaway here is that we are really just starting the biennial budget process. We released budget instructions to our agencies to start preparing materials just last month. And this is a process that will continue all the way through the end of session, but hopefully the passage of a budget and a signature by the governor before the fiscal year ends. The other takeaway here is that the numbers that I will give you here in a few minutes will be updated twice before that process is done. So they'll be updated with our November forecast and our February forecast. So this gives you a flavor of where the financial position is of the state today. But it's the November forecast that the governor will base their budget on. And then our February forecast that the legislature will enact a budget off of. And so numbers are going to change. So again, a good flavor of this, but just know that numbers will be updated at least twice throughout this process. Any questions? So this is likely what you're looking for. Most people do. This is a very high level statement that shows the position of the state's general fund after, again, our end of session. Most people look at the bottom of the slide and look at the remaining balance. Because you'll see that right now we estimate at the end of this current biennium a balance of $3 billion in our general fund. But in 28 and 29, when we look at the next biennium, we have a small shortfall of about $55 million. And one big caveat on that $55 million shortfall is that includes discretionary inflation that we are required to put in our forecast for law. So you'll see in that green box, there's about $1 billion that we estimate in inflation that we've booked in 28, 29. That is what brings that estimate down to 55 million shortfall. If you were not to include the inflationary estimate, it's about $1 billion positive balance in 28, 29. What we expect right now. Again, going to change it. I have a few more slides that looks at this in a little bit other or in a different way. This next slide here depicts it more visually. If you look at the 26-27 biennium, you'll see the remaining balance of $3 billion. But if you look at the structural imbalance that the state has, that's how we don't have that $3 billion in 28, 29 when we end we don't have that $3 billion that continues into the future. So that structural imbalance, again, is we are spending more than we are taking in revenue. And so it's not a sustainable way to spend. We also include in here that inflationary estimate again. If you look, we include that in the structural imbalance, but if you were to take the inflation out, you would see where there would be $1 billion balance at the head. The other thing that's going to happen in November is that we're going to put fiscal years 30 and 31 on spreadsheet. And so when we do that, which by the way, I remember when we put 20 and 21 on spreadsheet, and I was like, I'm never going to be here when we put 30 and 31 on, and here I am. The biggest thing is the story that we want to tell is that it's just not sustainable, this level of spending and revenue collection. And so when we put 30 and 31 on, it's likely going to look quite a bit worse. And the way that you see that is in the next slide, where we look at the long-term budget outlook. If you focus the attention on the annualized growth percentage, here you'll see that our revenues are expected to grow about 2% annually, and our baseline spending is 2.2%. So again, even when we look year over year, we're growing, we're spending more than we are collecting in revenue year over year. That's on baseline spending. If you were to include some of the carry forward money that we carried forward in 24-25, and if you looked at discretionary inflation, you included all that, that kind of depresses the annualized growth rate to 1.6%. But a truer look, in our opinion, is that baseline spending. The structural imbalance is, you'll see stated here, is about a $3 billion structural imbalance, and again, about inflation of 2. Any questions on that part? Well,
let's hold it until we get through.
One thing that our state does that not many states do, and that is we have a 4-year budget outlook. Only a handful of states do it. That gives us a lot of advantages. We're able to understand decisions that are made today, what that might impact budgets in the future. It also allows us to anticipate problems that are on the horizon and start to deal with them today. So that's, gives us a lot of good opportunity to inform decision makers in those situations. The good news is that our structural imbalance has been something of a priority for the governor and the legislature over the last couple of sessions. And you'll see this really illustrates that. If you were to go back to February 2025, when we released that forecast, we were anticipating a $4 billion structural imbalance. And if you included inflation, even more than that, almost $6.5 billion. And through a series of changes made over sessions in 25 and 26, you'll see that decision makers have basically cut that in half, almost 50%. So there's still a lot more to do, but it has been addressed by our policymakers over the last several sessions. The other thing about this graph that I think is notable is just how much forecast can change numbers. And you'll see in November 25 how the structural imbalance was almost 4.5 billion before inflation, and then in 26 it came back down. So there can be, quite a bit of fluctuation, forecast to forecast. Keep it in mind as we update our numbers in November. So where does the money go, and where does it come from? So here's a little pie chart that shows in our current biennium. In revenue, we expect to collect about 67 billion in revenue. Most of that comes from our income tax or sales tax. And where do we spend it? 71 billion for this current biennium. We're spending 37% in E12 education and 36% in health and human services. So a majority of our general fund goes to those two programs. And how do we spend it? You'll see there that most of our money goes to aids to individuals or grants to schools. Only about 8% is spent on compensation. Looking at FTE in 2025, which is our latest numbers, we'll have 26 here shortly. We had about 20,122 FTE funded the general fund, and you'll see the breakout there of which agencies So that was a branch, a little bit over 4,000 FTE direct care treatment. About 3,600 FTE. Corrections, 4,200 FTE. I wasn't able to look at FTE over time, this presentation, other than FTE growth was about 1,500 FTE from last year.
Just a clarification,
Yeah.
FTE,
Full-time equivalent, so individual that works the 8 hours, 0 hours. It's not necessarily the same as headcount, since a person can work part-time. A little bit about our general fund reserve. You'll see that the general fund reserve has grown over time, thanks in part to our general fund reserve policy. The idea here is that we have a general fund reserve of about $3.8 billion. And part of that is for our cash flow account, about 350 million of it. And then in this last legislative session, decision makers decided to carve out about 500 million for hospital stabilization. And so it broadened the use of our fund in the event that a hospital needs self-support. There is $500 million available, and the hospital has to meet certain requirements and specifications that are. But that 500 million can also be used for what typically the budget is for. Talk a little bit about driving the growth. As I mentioned in the pie graph, most of the general fund spending is for education and health and human services. This is a graph that shows how that spending has changed over time. And the big takeaway here is the green bar, which is the health and human services bar, just the growth that we've seen over the last 10, 15 years. And how that has compared to education or just all other state services. So growth is really driven by our health and human service spending. I'll talk a little bit about which part of health and human services here. Look at it as a percentage of the state budget. You'll notice that now health and human services and education are about the same proportion of the state budget. If we were to go back to 2017, it's a lot. So it's a very big. The reasons for the larger growth in health and human services is really driven by our long-term care waiver services. And here's a graph that shows that over time, each one of these lines depicts a certain category of medical assistance for our Medicaid spending. Green bar is our long-term care waiver services. The blue line that's at the very bottom, if you can see that, it's almost black, is our long-term care facilities. Long-term care facilities is what you would typically think someone that's in a nursing home or in some type of institution. A long-term care waiver is kind of what it sounds like. It's us. You're seeking a waiver from the federal government, from CMS, to place the individual in a home and community-based program rather than in that long-term care facility. So there's been a lot of growth in that area where the services are provided in the community versus in the nursing facility or the light blue and the red lines. You can note those two different colors. Those are 4 programs that provide the actual health care. Medicaid, so we call it basic care, but it's the health care services for elderly and disabled, for our families with kids, and with our adults. And the big takeaway here is what we expect by 2029, that 1 in every 8 general fund dollar is expected to go to a disability waiver program or CPS. Education also growing. It's really special education that's growing faster than general education, and you can see that depicted in this chart over time. There have been several efforts in the last couple of sessions to try to curb growth in both long-term care waiver services as well as special education through ribbon commissions and task force, as well as other interventions to try to curb that growth. And that's kind of the last of it, other than where to find information on MMB's website. There's kind of two main places. There's our budget website and then our forecast website, which I put there if you're interested in finding more information. We'll release our enacted budget, which is an interactive webpage that you can dig into all the different proposals and change items that were passed this session. There's descriptions about it. You can kind of dig in a little bit more into the budget, and that should be published here.
So we're in the 2026, 2027 biennium,
That's correct.
and that ends June 30th, 2027.
That's correct.
And then the next biennium is 28, 29,
Correct.
and that ends June 30th, 2029.
That's right.
How about the add protections to take out the June 30th, 2031?
And so we'll have 5 years really of budget.
And these are highly accurate projections, and there's a really good track record at MMB. And then you go back about 20 years ago, there was a commission known as Randall Weber Commission, outlining budgets. And almost everything about the growth of the human services budget could essentially have come out of the Randall Weber report. And it predicted the squeezing of K-12 education, squeezing of higher education, squeezing of all other expenditures, and this sort of growing wedge of human services budget. So knowing doesn't mean that we know what to do about what we know. But this is a pattern that we've gone for a long, long time, tracking to the baby boom. So just a couple more questions. We're setting one salary today, the OIG salary. And it's hard to imagine that any salary we ever set for that salary would affect any of the long-term trend lines.
I think that's part of the context that we're providing here is that really the drivers of growth in our state budget is not around compensation necessarily. It's in these two areas. And so if that's what you're getting at, I think that context is correctly interpreted that
we're recommending additional salaries.
Sure.
If, what is the percentage that the judicial system as a whole takes of the state budget?
Yeah, it's 1.8%.
So whatever we recommend today would be some percentage increase that would affect that 1.8%.
That's right. So even if, I don't know what the percentage of salaries are.
Yeah, but, Jim?
I first want to thank you for hearing short notice. I know that was short notice, Mr. Bunch. But I do perhaps have a different perspective from the chair. And that is last point that the chair made. When you set salaries for agency ads, you are having an impact on negotiations in that folks look at, you're setting the salary, shouldn't we get similar pay? Now, whether that actually enters into negotiations, I don't think it really did in 08, 09. Again, zero funds basically for the bargaining. Nonetheless, kind of also point out here that inflation, discretionary inflation is an economic term. It's not normally used in forecasting. The law was changed back to what it was originally before 2003 to say you're going to pound inflation. It's no bargaining. I mean, inflation exists. It exists. It exists on the revenue side as well as the expenditure side. So to say we're not going to pay attention to it on the expenditure side, I think is a little bit absurd. One more question, and that is, looking at what you have here in the decrease between November number, which showed a 5.4, November of 25 showed a 5.4 billion structural deficit, and February forecast for any activity at the legislative level, that was decreased to 3.3 billion. And the commissioner pointed out that that forecast was put together, not taking into account natural surge, not taking into account the war in Iran, not taking into account proposed Medicaid and Medicare cuts, which were significant given federal legislation. One more thing, just to update your information to this week, if you know, the quarterly came out, and this is on the national level. Our consultants that basically gives us the basis for the forecast. Here's what they now expect that this calendar year, we're in the middle. Gross domestic product will only grow by 2% when it's in the February forecast, they had it at 2.7%. Conversely, on the inflation and of course that's going to affect this inflation number, CPI inflation has increased to 3.4%, up from 2.5%. Again, in this calendar year, this is an unprecedented shift within 1 year. We've not seen that before. So forecasting is not an exact science. And those are 35% shifts in major areas of the budget. So please comment. I think we're in some trouble here.
So appreciate those comments. Certainly those factors will be incorporated into the November forecast, along with updated information that is happening from now until basically October. And so that is one of the reasons why we do a November forecast, is to continue to update it. It's one of the reasons why we do a February forecast just shortly after the release of the November, is to try to get the best, latest, and greatest information incorporated into our fund statements so that decision makers have the best information that they have when they set the budgets. But you're 100% correct. Like there is a lot of risk in the forecast, if that's what you're suggesting, and our numbers will change. And what you are suggesting for GDP and CPI, those are all factors that get incorporated and will be updated.
So your best guess, would we be closer to that 5.4 billion in November, or are we going to be, either way, it's the worst since the middle 1980s. So the worst structural deficit we have faced.
Yeah, it's hard to estimate that. I think those factors, there's a whole other side of the ledger, that's the spending side as well. And kind of what are the changes that we're seeing in our health and human service usage and cost per level of education, right? It's changing there. So there's a lot of elements that can change between the forecasts. So it's, in my mind, it's obviously too early to try to anticipate where this is going to land.
Other questions?
Just as a location, is there a place that we can look at comparable budgets of other states and how they compare with the Minnesota budget?
Yeah, there is. There's the National Association of State Budget Officers. It's called NASBO, which we are a member of. They have a website, and they produce annual reports. One of them that you're probably looking at is the Fiscal Survey of States. They just released their 2026 report. So you'll see information that we sent in from Minnesota, and in that report, you'll see a comparison of all the other states that participated in the survey, which is one state. It includes things like budgetary balances or rainy day funds, how that compares, how states have addressed shortfalls. What measures have they taken? Did they raise taxes? Did they decrease spending? Did they do both? Did they dip into their rainy day fund? It's a great source of information.
Say that source again, please.
Yeah, National Association of State Budget Officers.
Thank you.
Our recommendation will then go to the next step. And budget process will start after the governor's elected, but before the governor takes office. And there'll be a transition team. So at some point, that governor will make a decision based on a myriad of factors about how much they want to write into their budget. The entirety of our recommendation, more or less, that's the judgment of the next governor. And then from there, that budget proceeds to the list.
And the governor will release their budget likely in February. They get a little extra time because it's a new administration. Typically the governor by law has to release their budget in January. And it's kind of odd and tiny because the governor will release their budget in February and then they'll show a turnaround a forecast that changes the numbers, and then that government will have to revise their budget likely in March based on that.
And the 2027 Compensation Council is likely to have past history to be appointed sometime in mid-February. And then begin to weigh in on the next set of duties that the Compensation Council has. So other questions for, and then go ahead.
Will there be some, maybe that addresses the salary figures and some draft resolution considered later today?
Yes, and I should take a moment. Folks who are online, members, are there any questions from you? I want to specifically make sure you get heard. Testimony, thank you much.
Thank you, Chair. Thank you, members.
Next up. We're gonna jump straight to Jeff Sharbuck. Item 6 on your agenda, and he is the state court administrator. But Jeff, it was.
Good afternoon, Chair McCormick and members of the Compensation Council. Thanks for inviting me. I'm Jeff Shorba. I'm the State Board Administrator for the Minnesota Judicial Branch. And we really appreciate the opportunity to be here today. So I want to talk to you about judicial compensation in Minnesota, where judge salaries are standing today, and how they compare with the broader legal market and the other states. More importantly, what we're seeing in the recruitment of experienced attorneys to the bench and how the Judicial Council believes we should address that issue. So let me start with the larger picture. For several years, Minnesota has worked to keep judicial salaries competitive enough to attract experienced attorneys to the bench. This council has consistently recognized that need and recommending meaningful salary increases.
including a 6% decrease each year of the current biennium. Judicial branch made the same request. The budget enacted by the legislature in 2025, however, did not include a judicial salary increase for either fiscal year 26 or 27. The Minnesota judges are now serving through 2 consecutive years without a pay adjustment. That comes at a particularly difficult time. Compensation for experienced attorneys, for judges in other states continue to move, while Minnesota's judicial salaries remain flat. At the same time, we are seeing fewer attorneys apply for judicial vacancies. And as we will discuss, the need for judges is growing, not shrinking. A recent statewide workload study found that Minnesota needs about 40 additional district court judges to manage current caseloads effectively. That is about more than what judges, this is about more than what judges are paid in a particular year. It's about whether Minnesota really can continue to attract and retain highly qualified judges, particularly as the demands on our courts increase. So the Judicial Council is currently developing the branch's budget request for the next biennium, which will be finalized in September. However, I'm pleased to share that just this morning, in anticipation of your meeting this afternoon, the Judicial Council voted to support an increase to judicial officer compensation by 10% in fiscal year 28 and 4% in fiscal year 29 in order to address these serious recruitment issues facing our judiciary. Because that process is still underway, the council has not fully determined what other requests we'll make from the legislature, but they did vote on limited judicial compensation of 10-4. So before turning to the salary data, just let me briefly describe the size and structure of Minnesota's judiciary. We have 322 judges serving across 10 judicial districts, Court of Appeals, Supreme Court. Together, they process more than 1 million cases each year in courthouses across the state. Although the judicial branch is a fully separate and co-equal branch of state government, it accounts for slightly more than 1% of the state's general fund budget. For that investment, Minnesotans have a statewide court system handling everything from criminal and family cases to civil disputes, housing matters, child protection, and appeals. Courts are fundamentally a people-based operation. About 90% of the branch's budget goes to salaries for judges and court staff. The branch does not have an independent source of revenue that can be used to fund compensation increases. The fines and fees collected by the courts are deposited in the state's general fund, and judicial salaries, as you know, are established by the legislature. As a result, maintaining competitive judicial salaries requires a direct state investment. Given the scope of the work courts perform for a little more than 1% of the state's general fund, I believe the judicial branch continues to be a very strong investment for Minnesota. You're probably aware, but these are Minnesota's current judicial salaries. Because there were no increases for fiscal years 26 or 27, they'll remain unchanged for these 3 consecutive fiscal years. Standing alone, these may seem like strong public sector salaries, but judicial compensation cannot be considered in isolation. The key question is who in Minnesota is trying to persuade our people, our attorneys, to leave an established legal career and take on the responsibilities of serving as a judge, and whether these salaries are competitive enough. Minnesota needs judges with deep experience, sound judgment, and a demonstrated record of excellence. We need a bench that draws from a broad range of legal practices, communities, and professional backgrounds. To attract those candidates, judicial service must be a realistic and competitive career choice. And as the next several slides will show, Minnesota salaries are becoming less competitive with the opportunities available to the attorneys we most want to recruit. I know this chart looks busy, but it's worth walking through because it tells an important story about what has happened to judicial salaries over time. The first column shows judicial salary increases by fiscal year. You can see that of the 8 years shown here, judges received no salary increases in 3 of them, 23, 26, and 27. Those years really matter. Market does not stand still during a salary freeze. Wages continue to rise, inflation continues to increase the cost of living, and the gap gets wider even when the salary itself does not go down. That's what the middle column shows, wage and salary growth across Minnesota's economy. This gives us a sense of how quickly the broader labor market has been moving, including the market which we're trying to recruit experienced attorneys. The final column shows inflation, which tells us what has happened to purchasing power over that same period. When you step back and look at the cumulative numbers, judicial salaries will have grown by about 21% from 2020 through 27. But over that same period, inflation is expected to grow by roughly 32.5%, and Minnesota wages and salaries by nearly 41%. So while the larger increases in fiscal years 24 and 25 were important, they have not been enough to offset the years with no increase. Over time, judicial salaries have continued to lose ground against both the cost of living and the broader market. Here's where the impact of that widening gap becomes even more apparent. District Court judge in Minnesota earns about $190,000 a year. By comparison, the average salary for a Minneapolis attorney with 15 years of experience earns about $205,000, and the average base salary for a law firm partner is about $242,000 before bonuses. That matters because those are the kind of experienced attorneys we want to attract to the bench. Many of them becoming a judge will require accepting a pay cut, sometimes at a point where their careers have substantial financial and family obligations. Same issue exists in the public sector. Several county attorneys now earn more than a district court judge, and in some cases more than Court of Appeals judges. At a practical level, that means judges may earn less than prosecutors appearing before them. The issue is not that these attorneys are overpaid. They are experienced professionals doing demanding and important work. The issue is that judicial salaries need to be competitive in that same market. Minnesota wants its strongest and most experienced attorneys to view the bench as a realistic next step in their careers. Every year, Minnesota is losing ground against other states. Each year, the National Center for State Courts compares judicial salaries across the country and adjusts the figures for differences in cost of living. This gives us a much more meaningful comparison than simply looking at the dollar amounts from one state to another. So in 2021, Minnesota ranked in the top half of states at every level of the judiciary. 18th for district court salaries, 20th for the Court of Appeals, and 23rd for the Supreme Court. By 2026, that position had slipped considerably. District court salaries fell to 21st, Court of Appeals dropped to 28th, and the Supreme Court to 32nd. So Minnesota has gone from being solidly in the top half, beginning to fall to the bottom half, particularly at the appellate level. With salaries frozen here while other states continue to make adjustments, we should expect that trend to continue unless it is addressed. This matters because Minnesota is competing in a national legal market. Experienced attorneys have options. And judicial service has to remain competitive, not only with legal careers here at home, but also with judicial opportunities elsewhere. There's another part of the recruitment challenge that we also need to acknowledge. Both nationally and here in Minnesota, threats directed toward public officials, including judges and court staff, have increased in recent years. Tragic events here in Minnesota last summer were a sobering reminder of very real risks faced by people who serve in public roles. To better understand what this looks like within our own court system, the judicial branch reviewed reported safety and security incidents from 24-25. The results were really concerning. Total number of reported incidents increased by 47%. Threats to persons, to oneself, or to property increased by 85%. And reported disturbances inside court facilities increased by 50%. Those numbers matter because they speak to the reality of modern judicial service. Serving as a judge has always required a willingness to make difficult and sometimes controversial decisions affecting people's families, finances, freedom, and safety. But increasing threats, harassment, and concerns about personal security add a significant burden to that role. Attorneys considering the bench may understandably weigh the risks to themselves and their families, particularly when other legal careers may offer higher compensation with far fewer personal safety concerns. So we're asking talented attorneys to leave established careers, accept a salary that is becoming less competitive, take on an extraordinary workload, and serve in a public role that may expose them and their families to heightened risk. That does not diminish the commitment of the judges serving today. In fact, it should deepen our respect for their commitment. We know salary alone cannot eliminate these risks, but competitive compensation is just one important way for the state to recognize the growing responsibilities and sacrifices that come with judicial service, and to help ensure that Minnesota can continue to recruit and retain exceptional people willing to take on this vital role. The trend shown on this slide is one of the biggest concerns. Strength of our court system depends on the people willing to serve as judges. There are individuals we trust. These are individuals we trust with decisions involving public safety, individual liberty, families, children, housing, businesses, and constitutional rights. We need to be able to attract outstanding attorneys with the experience, judgment, temperament, and integrity those responsibilities demand. But the pool of attorneys willing to apply is shrinking significantly. In 2020, Minnesota received an average of nearly 15 applicants for each district court vacancy. By 2025, that number had fallen by 38% to just over 9. And through the first half of this year, the average has dropped to about 6 applicants per vacancy. I recently received a phone call from 7th District Chief Judge Michael Fritz that brought these numbers really to life. His district had 2 judicial openings and received only 8 applications in total. And the applicant pool was so limited that the openings had to be reposted. For context, when he applied for the bench about a decade ago, there are 26 applications for a single opening. Smaller pool doesn't mean that there are not qualified applicants, but it gives those responsible for judicial selection fewer choices and makes it harder to build a bench that reflects the full range of talent, experience, expertise, backgrounds from across Minnesota's legal community. Between a salary that is no longer competitive with the market and the other costs associated with taking on a high profile role, public service, Minnesota is facing a very real and growing challenge of attracting qualified attorneys. Compensation is not the only reason fewer attorneys may be applying, but it is one of the most significant factors the state can directly address. Frankly, if this trend continues, the concern is not simply that we'll receive fewer applications. It's that over time, Minnesota may lose access to talented attorneys who would make exceptional judges, but conclude that judicial service is no longer a realistic choice for them. The discussion about competitive judicial compensation could not be coming at a more important moment. Last year, every district court judge in Minnesota participated in a 6-week weighted caseload study tracking the time spent on both case-related and non-case related work. Gave us the most detailed picture we've had in years of what it takes to manage today's caseload. Study found that the work has become more complex, more demanding, and more time intensive. Based on the current caseload, Minnesota needs, as I mentioned, approximately 40 additional district court judges to manage that work effectively. That represents about a 14% increase in the number of district judges statewide. This is a significant need, and the judicial branch has begun planning and working with the legislature on how to address it. But securing authorization and funding for additional judges is part of the challenge. We also have to attract exceptional attorneys to fill those positions. That is why compensation and workload are so closely connected. Same time, Minnesota is preparing to make the case for a larger bench. Number of attorneys applying for judicial vacancies is falling. Competitive salaries will be essential if we are going to attract qualified attorneys needed to fill those positions. As I said, as I started my presentation, the Minnesota Judicial Council, our statewide policymaking body, consisting of judges and administrators from across the state, is currently in the process of developing our next biennial budget. The council expects to finalize that budget in September. However, council really appreciates the important role compensation council plays in the process of determining judicial compensation. And recognizing your meeting today, wanting to make sure you had the most up-to-date information, we suspended some of our rules this morning and voted on a recommendation for an increase to judicial compensation. So again, we're going to be asking the legislature for a 10% increase in fiscal year 28 and 4% in 29. We believe the higher number, fiscal year 28, will help address the consequences of pay freeze our judges are currently working under. And the 4% increase in 29 will help those salaries keep pace with our public sector peers. And we hope the Compensation Council will seriously consider this request. Ultimately, the issue is about having qualified attorneys perform justice for our state. Judicial salaries are not kept pace with inflation, the broader labor market, or with compensation available to experienced attorneys. So you can see from this presentation that Minnesota is losing ground. And more important, we are seeing a sharp decline in attorneys willing to apply. At the same time, our need is growing, as I mentioned. It's going to require competitive compensation. This council has recognized that need before. We hope we will do it again, make a strong recommendation to the legislature in support of competitive judicial compensation. So thank you so much for your time. Happy to answer any questions I may have that I've answered.
I'll start by saying, sure that your presentation was exemplary. I wish I could sign this to allow other people to make presentations across the legislative executive processes. But I also found it appalling in the discussion of the problem that you laid out. And So it's a real challenge for the compensation council to figure out. I don't think we want problem to persist. That's just my very honestly stated editorial. But we have people here who no doubt will have questions for you. Right to my right and look to my left. Questions, anybody? Over there on the left, Amanda.
Yeah, thank you for being here. You mentioned issues and struggles with recruitment. I'm wondering if you or the council has perspective on retention, and to frame that or tee it up for you. We heard from the Judicial Selection Committee this morning at the top of our meeting, who expressed the view that there are not issues with retention, which is of judges based on salary, which is a little bit at odds with what we had heard at our last meeting, both from Judge Kyle and the Minnesota District Judges Association, and the report we received from Professor Banyan, both of which reported that judges are retiring earlier and seeking jobs with additional compensation. I'm wondering if you or the council have any additional thoughts on retention and how salaries are playing into that.
Sure. We have not done a formal study, but we do keep track of the records that we have. So some of this is a little bit anecdotal, but we do have full records. It used to be that a judge would stay till they were at least 65. Many judges stay until mandatory retirement of 70, or used to. Now we're seeing judges leave the bench to go to county attorney's offices, to go to the private sector, leaving in their 50s, early 60s, much earlier than before. And I believe some of that is due to compensation. Some of it, frankly, is also due to burnout. This is a great job, they all say at the beginning. And then as time goes on and they become overwhelmed with the amount of work, they say, I don't really know, given the compensation, if this job is really right for me. And now we're hearing a lot of them say, I don't know if this is right for my family because of security concerns. So it's a combination of workload, compensation, security. I would say those are the triangle of issues that we are dealing with. So I would concur with the District Judges Association that it's not only recruitment. We are also seeing a trend negatively in retention.
Just a related question, which is the note here that the district court judges are managing increasing complex and demanding workloads, and the idea that the judiciary has to, increase in size by as many as 40. What's driving that? Because you're saying it relates to retention. Obviously, it's going to increase the demand for judges, but what's driving the bigger workloads for the existing judges?
So there are a lot of factors. One big factor is self-represented litigants. Number of cases that our judges are facing where either one or two parties are self-represented, especially in family cases and some other cases skyrocketing. And those cases, of course, take a lot longer time and effort. We're seeing a big increase in use of interpreters, and interpreter cases take longer. As our population continues to broaden, we are seeing not only in the metro area, but obviously in rural areas, the use of interpreters being a big factor. The other thing that we're seeing is the evidence and other things that are coming in from cameras and body cams and other kinds of things, making going through those kind of criminal cases much trickier for our judges as they try to grapple with those particular cases. And the number of family cases are continuing to increase, whether those are divorces or those are child protection matters. I mean, it's hard to go by in a week without seeing some child abuse somewhere. So DHS statistics point that out. Those cases eventually all come to court. So cases like traffic, those kinds of things are going way down. Cases where we have parties that are self-represented, the cases are more complex. are going up. So it's taking more time on the part of judges to handle those complex cases.
Yes, I was wondering if you would comment a bit on what the court's caseload is and how that's grown over time and maybe how that translates in individual judge caseloads.
Yeah, so as I mentioned earlier, we handle about 1 million cases a year. Now, some of that is smaller cases like traffic. We saw cases decline during the pandemic. There were less filings, but I will say that they have bounced right back and continue to actually rise in some of these complex areas. So we had a little reprieve there where we had time to work on the backlog that we had gathered during the pandemic, got that backlog down and away, but it's starting to build up again because of the number of cases that are coming in and the complexity of the cases that are coming in. So that's why we were prompted to do another weighted caseload study with judges. We wanted to find out what's really going on here. When you have a judge track their time every day, all day, whether they're working at 10 o'clock at night or 6 in the morning, you get a very good perspective on the areas that are giving them the most trouble. That's how we came up with this number. It's really a math equation. You look at the workload and you look at how long it takes, and by the workload, I mean filings. You look at filings and you look at how long it takes to do various cases. You just take the number of filings in family and you multiply it by the length of time it takes to go to family courts. You come up with a need. So it's not like we're putting our finger up in the air here. This is a math thing. Math is not my thing, but we have great people who do math, and they have come up with these numbers very, very solid way to reflect what we see as reality. So.
We go Jim and then Devin.
I have a few questions, Mr. Shortman. Thank you very much. Now I figured it out and then schedule. You had to have very short judicial council meetings last month, this month. And we're here on this timing to accommodate the courts, and that's very appropriate, but thank you for doing that. And I do hope we get to see your video from today because it wasn't posted this morning. We would love to review that.
Yeah, we were holding council offsite in Hennepin, so it may take a little longer to process that.
Oh, that's fine. I don't know if going to actually act today with new information. I hope you don't have to think about it, but that's another matter. I want to ask you a couple of things. First, this is, as the chair said, you've always done great presentations. I think almost everyone here agrees with the need and wants to accomplish this. The problem is that we accept your recommendation or the MPGA's recommendation, however you heard them. I think the legislature looks askance as I recall in 23 when then Chairman Kaplan said we have to be reasonable in the legislature, probably adopt what we are at. And that I wasn't on the council then, but I thought it was a very wise thing that Mr. Kaplan said. We are not getting this, yes. Chairman Cormick said, we're not getting the same level of feedback from the other partners, from the executive or the legislative. Legislative wasn't even represented here until, these 2 years. But the question really is, to me, where do we set the perfect recommendation that influence the legislature at your interests, because I have to be honest, with the budget situation, 4 on the tail end makes a lot of sense, and 14 to catch up, or I'm sorry, 10 to catch up, 14. 10 to catch up makes sense to me, but in the scheme of things, how is the legislature going to look at that? And then just one more thing, if you could, I'm asking you for math, but out of your 929 million, our part of it, what percent is the judges itself, not judges and staff? So if you can give me a rough idea, is it 60% or just the judges, what we're running? Thank you.
So, the judge salary portion of our overall budget is one of the largest portions of the budget. I believe, I just heard this yesterday, don't totally quote me, but I believe it's around 25% of the budget, is judicial salaries. Now, the rest of that budget includes, all the salaries for our other employees, operational costs and other things, but it's pretty big. To your first question, which is the trickier question, if I could predict what the legislature would do, I'd be a very wealthy man. We did not have much luck, even though we thought we gave a very reasonable request of 6 and 6 last biennium, and we got absolutely nothing. Now, the legislature will tell you, well, that was due to targets and leadership gave us targets and we didn't have any room. And so we had to sacrifice something. But from our perspective, that doesn't mean that we don't ask for what we need. Because if we don't ask for it, it's not on the table. So that's why our council felt very strongly this morning that we need to ask for what we need. We may not be successful, but we don't negotiate it against ourselves. And we have always, I hope, had a reputation over at the legislature that we are reasonable. We are not asking for outrageous amounts, hoping that we get half. We are asking for what we need. And that's where they came up with the 10 and 4. We will have to plan very strategically as to how we're going to try to address the legislature. We'll get a whole new legislature, a whole new governor. So everything will be up in the air. And we already begun to work on various strategies to do that. But this is the first stop. Compensation Council is the first stop. Then once we put our budget together, we'll be hoping the governor, whoever that is, puts it in his or her budget. And then we'll be on to the legislature. But we know it's an uphill battle. We got 8 and 4 the last time. We had about a $3 billion surplus. Now we have a $377 billion surplus. So we understand it's tough. It's a tough road. But we can't ignore what's going on with judges. Yeah, we have to ask for what we think is important because we feel like we're sort of edging towards a cliff here. All the indicators are we're not going to get the right people to take these jobs unless we start to do something. So that's why we put out the 10 and 4.
Yeah, I just want to follow up so that you can clarify for me the 0 and 0. I understand it. On your end, I don't know the specifics, but help us understand that some of it was you had a certain amount of money and you decided that, okay, we needed to address whatever the needs for the public defenders or what, trouble at the appellate level in terms of need for administration. Things like that got in the way, or not in the way, but you prioritized for that. I mean, you must have said, okay, we're going to address this area, or do you think the legislators just said 0 and 0 is what you want?
We don't control what the public defenders ask for. They're governed by a board that determines their budget request. We did not ask for any money for the appellate courts. When we asked for the 6 and 6, we asked for 6 for judges, 6 for staff in both years. We asked for some money for mandated services, which we're required to pay, like psych exams and interpreter costs, that are just unfunded needs because we have to pay for them. So we need money for them. We asked for a small deficit in cybersecurity, and insurance. And that was pretty much it. And what they said to us is we just don't have the target from leadership, and therefore we can only give you 0.9% in the first year for staff and nothing for judges. So we never prioritized anything above judge pay. That's not the way we generally work, which is, as I said, negotiate against ourselves. So we did not negotiate against ourselves. We thought it was a reasonable request, given the situation. When that spreadsheet came out, I was surprised. Anyways.
Sure, I heard you say that 25, if you think roughly 25% of your budget is judicial salary. Earlier, we had a presentation from Minnesota Management Budget that said there are 4,234 FTEs in the judicial branch. I understand from your report, it's 322 judges. So recognizing salary differences are going to be different against classes, things like that. But the action for the FTEs, judges make up about 7.5% of your total workforce. Does that sound about right?
No, I don't know how MMB comes up with numbers. We have our own classification system and compensation system. MMB, I don't know what they look at. Maybe they look at payroll or something. We estimate that we have about 2,500 employees in the judicial branch. Now, maybe they're looking at vacant positions or something. I don't know what they're looking at. I have my HR director here. She's agreeing that that number is not correct. So you can certainly check with them, but our estimate on FTEs is about 2,500. Thank you.
Chair, clarification, Dentez last year that we did recommend a 6% and 6%, didn't we?
Absolutely. Last year's recommendations from this group were 6% and 6%.
And that was not brought forward through the legislature.
And just to remind you, these are recommendations that not to be set. Are there any questions from the folks online? Sure, once again, you can put your hand up and I'll be notified if there are any. Other questions here from folks at the table, right, Eric?
Sir, just, I know we're not part of the compensation, but the security and the threats that are going on for the judges and our courtrooms. I don't know what you're looking at addressing that, or how do we decide? I don't know. That's a big issue that we're not addressing here. And I'm just wondering what you're doing as your organization to address some of those issues.
Yeah, so we did have a small legislative package that we took to the legislature last session. There were two components that we modeled after the legislature itself. One is to try to get judge information offline so that people wouldn't be doxing people or following them on social media, trying to get our judges to stay off of social media. But so we have financing now for a service called Delete Me that help get things off of the web. We also got some money to help provide for home security for judges. You don't have it, some money to help put it in, and then some money for ongoing maintenance. The other thing that we asked for, we have one security person for the whole judicial branch, all 87 counties, 102 locations. And that position started about 5 years ago before all of this hit the fan. So we asked for 2 positions to help us with that. And we are currently advertising for people with law enforcement experience, particularly can help us do threat assessment. Because when a judge gets a threat, their first question is, what do I tell my family? Should I stay living here? Should I go to a hotel? How serious is this? And the longer it takes to get that answer, the worse it is. So we work closely with the BCA to try to figure that out, but we can't overwhelm them. They have all the legislative stuff to deal with. So we're trying to take some of that on ourselves. And then we received $4 million in one-time money for a security grant program. So counties can apply to add more cameras or put ballistic film over windows and chambers and other things like that, or bulletproof the bench. So we are starting now to advertise to get applications from counties for that. And 4 million is the most we've ever received for that kind of program. So we're looking forward to getting a lot of applications and being able to fund that. So that's our sort of start. We did tell the legislature we may be back. So see what happens in this particular budget request.
Thank you for addressing it.
Zorba, I think we're going to include the testimony there.
Great, thank you very much.
Thank you. Turn to the vice chair.
Thank you, Mr. Chair. I think, so at this point, consistent with what we talked about before, I think we could, did you want to entertain discussion or move to a motion on this?
Entertain the discussion, and if there's a motion, go ahead.
Okay, well, I just wanted to, I guess I wanted to weigh in on a couple of things on this. First is that we have had discussion the last, and really not that far out from where we were in March of 2025 or May of 2025. We were talking about this last time and we proposed 6% twice over 2 years, and legislature did nothing. But the commentary I had is that, I've been on the committee now for since 2017, I think. Most of those years we made recommendations that were ignored. The time that we didn't make recommendations that were ignored, we went in with a proposal that we thought was supported widely by the evidence we had and the circumstances. I think that at least we had wide agreement last time we spoke that the salaries for judges should be higher and should go up. It's just a question of what number we thought would work and potentially be adopted. So all that goes to the document you have in front of you, which is the motion the chair and I put together. We talked about doing that motion today, so I would be willing to move it at 6% for 27 and 28. And the reasoning for that is really, at least what we heard last time, we heard before, all of the information Evans pointed toward that conclusion. The study from Professor Banyan, the testimony we heard all showed that those were numbers that seemed very well supported. I didn't realize they would have a higher number to offer us today, and can certainly discuss whether that's appropriate too, but my thinking was 6 and 6 just seemed obvious based on what we've seen, that I'm hoping that even with the budget that we'll be looking at, that would be acceptable to the legislature. So I'll offer that motion for start discussion.
Motion is made to move to recommend to the legislature an increase in judicial salaries of 6% on July 1, 2027 and 6% on July 1, 2028. Discussion.
I'll second.
Kevin?
Thank you, Vice Chair Ask, for making the motion. If I had my druthers, we would actually do the 6 and 6 with a fix that was proposed to us by the Minnesota District Judge Association last meeting. I don't get the sense that there would be consensus around that, which is why I've seconded this motion and will happily support it. I think that our job, I just want to say that I think that our job is to make the recommendation that makes the most sense for this body, taking into account as we can the economic data that's been presented to us. I don't think it's our job to try to figure out what 201 legislators are going to do. I don't think it's our job to try to figure out what 201 legislators who we don't know who they will be in January will do. We don't know who the governor is. Although by a weird circumstance, the governor doesn't sign the judicial salaries part of the bill because the judiciary decided that was the case in the 1970s. I think all we can do is take the information we have, make the best recommendation. I think that best recommendation is probably to increase their salaries further. But as I say, given the economic data we have, a safe recommendation is 6 and 6. I don't know why the legislature didn't take our recommendation last year. I suspect that politics may have played a role in that it is a political body. And we can't guess what that will be like with an entirely new legislature. It's possible that the chair of the Judiciary Committee in the Senate could not be the same, that's just as an example. And there will be a change in the House, and we just don't know. And so trying to guess, I think, is a waste of our time. And I think we've made this recommendation recently. It was well-founded. It remains well-founded now.
Discussion? And
I'll be voting no on the motion and just wanted to clarify, because I think we do need to implement the fix in addition to the 6 and 6. And I know that there's some concern, I agree with Devin that we're not supposed to be speculating about what legislatures will do. But I understand that one of the factors we are supposed to consider is the state's ability to pay. But to put that in perspective, we're talking about 25% of 1.8% of the state budget. So I think it's incumbent on us to make the fix for what was not previously adopted, to get our judges up closer to where the market demands that they be. And then I would support the 6 and 6 about that.
could I just ask a Chair's question for clarification? What exactly is the fix? How would that manifest?
Yeah, I'm looking at the Professor Banyan's proposals, and his standard 1 is restored compensation council of 6% plus 6% recommendation. That results in a salary of the district court judge for 2020, I guess we're at 7 of 219,000. My math, which could be incorrect, of the current proposal would put it at 201,000.
And I think to answer that, my understanding of the fix plus 6 and 6 is it's effectively a 12% increase over current, because it would adopt the 6 and 6 that the council had proposed in the past.
That would be 6%. And the way this is phrased is 6% on July 1, 2027. So what you would be suggesting is 6% on July 1, 2026, 6% on July 1, 2027, which is our past recommendation.
I don't think that's what the proposal, as I understand the handout from Professor Banyan from last go round, it would assume a salary on July 1st of 26. So this year, we would effectively retroactively include a raise. And that retroactive raise would be the 12% that didn't happen, which is how you get to 213 as an initial salary. Because 213, 614 is 12% over their current salaries. Does that make sense? Okay.
How would you phrase that?
Thank you for
How would you phrase that?
How would you phrase it in a motion? Well, it's not.
Not before us, but
If I were to.
It's hard because we're comparing percentages on some of the proposals versus straight salaries on the other proposals. So I think if I were to propose the motion, it would be to adopt a salary of starting July 1st, 2027 of $219,169. I understand that the current proposal, if we were to put it into dollars, would be $201,500.
well, we have the ask motion in front of us. Further discussion on the ask motion. And if you want to offer amendments to it, you and Tom.
I guess first a point of order, as I understood motion, if we act, well, if it passes, that does not preclude us from further moving. To adopt those things. Secondly, as I guess to Devin and to Jim's earlier points about trying to define what the legislature may do. We know that previously when we recommended 6% and 6%, they said no. So we have some empirical data. We also have very compelling evidence that 6 and 6 makes absolute great sense. And the fact that they're low, it should be higher. We also have the judicial branch or the judicial council endorsing the 10% and 4%. And so as a non-legislative operative, I'm trying to reconcile what is the right thing for us to do as a body, but also to as effectively as we can support the efforts, of the judicial branch and the judicial council and the district judges association are seeking to accomplish with the legislature. I don't know what the right answer is. I tend to lean towards the judicial council's recommendation of 10 and 4. But that wouldn't mean, wouldn't also support 6 and 6 if that's what this group wants to. But I struggle with guessing or what the legislature would do. And I'm trying to support those people who are actually going to be lobbying the legislature for something.
Personally, I think the worst thing we could do is negotiate against the scope and scale of the problem. Because a lot of times you have records of annual raises going, back every year, we get a certain amount every year. And we're basically dealing with inflation, spending power on a population, on our physical employees. And we don't have that here, we have a gap. And for better or for worse, the state government continues to do this where we freeze and hold and fall behind, and then we plunge forward with money to solve the problem. And the number one thing you have to have, I think, when you're ready to plunge forward is a description of the problem that makes you convinced that this is an extraordinary moment for societies. And I think that the presentation provided that. Sometimes that comes in the form of a Hayes study, sometimes it comes in the form of an NCSL study. And here it comes from the judicial branch itself. And it's clearly an unargued massive hole that has been created through case by case, year by year, decision to freeze this budget. Now we have a problem. And the problem is going to be exactly what they go. And so I don't think we can argue against ourselves profitably in this kind of situation by trying to feather in to something that is objectionable. And the result of that being that we put people in the position of saying, yeah, the judicial people said we have a hole in a problem, but we're just trying to be quiet and modest and just get us sure and solve that problem out here. That's not in my point. See a problem, we're supposed to work on fix the problem. So you have a motion of 6% and 6%. We have an alternative offer of 10% and 4%, which seems to be designed to fill that gap to some extent. We have a third alternative of setting the July 1, 2027 at the $219,000 figure that Amanda outlined. Potentially with a 2028 raise of 6% if we didn't do that. So those are three different things to go. Go ahead, Gary.
Well, just going back into 2024 and 2025, if you see the increases in 2023, it was 0. And for the next 2 years, they did have a combined 12%. So I think we can go back to use a validity of saying to correct the problem that they did do a 10 or an 8 and 4. And if we would be able to do a 10 and 4, I think it is really makes sense to, if you're addressing it, here's the problem right here today. And so I would be very supportive of a 10 and 4 option versus just a 6 and 6. So we're talking 12 versus 14.
I agree. I am in favor of the 10% and 4%. To me, the case for it has been well laid out. It's easier to understand than passing percentages and then offering an additional fix. It is, I interpreted it as the 10% as an attempt to try to be part of the fix. Because you've had 2 consecutive years of flat funding, and this is basically 3.3% each of those 2 years, and then the next year coming. And that's very modest compared to the more than 4% increase in the general labor market that we have seen over that same time period. And so We see it in other data that is compiled here by the judiciary and as commented by the chair of our Judicial Selection Commission in 2026, there was a significant drop off in applications. And when you look at the real effect of inflation and flat funding of our judiciary, you can understand that that compensation system is contributing to that. So I am in favor of adopting of the Judicial Council at 10% and 4%.
Motion in front of us is offered by Vice Chair Ash. Mr. Ash.
Thank you. I guess I'm sympathetic to all this, and I think we should increase more. And I'm also trying to catch up. I do like the idea that Mr. Boyd suggested of adopting the 6 and 6 and then adding the recommended fix on top of it to give options. I understand that there's concern about what that looks like from a negotiation perspective. But if we're just doing the fix, I think that's closer to a 13% increase. I'm concerned about going in with 13% as very high. I'm not pretending like I can predict what the legislature will ever do, but I do know that we've never gotten that or recommended it. And the highest, when we had a surplus in 23, we recommended 9, got 8. So now we have less money to spend. And so I guess my suggestion would be vote for my motion, 6%, that's 6%, and then I would entertain a motion to add on top of that too.
Jim, you have hand up.
I believe whatever we end up with, it makes sense to front load the increase more so than doing. Even if there are 2 reasons for that. One is obviously we're catching up. The other thing is we will be in a fiscal crisis in this year 2020. I just can tell you that having paid attention to the economics for an awful long time, also participated in responses to the forecast going back to 1993, not in recent years, but I continue to pay attention. So my concern, I'm going to tell you, I'm going to vote no today. Reason I'm voting no is procedural. I want this council to think about the proposals. I want anyone who has time to review the video so you understand what the Judicial Council proposed, because that came up just today. We didn't know it was coming. We have a deadline that's 6 weeks away. I have not been given an explanation of why we are acting today. Keep in mind, originally we were told we were going to meet 5 times for a full day. That probably was before the Legislative General Advisory Commission had come into existence, and I understand the pressure on the LCC. It's not fair, but we just have to do our work. We have to think about it. This is too soon to figure out, and so I'm voting no on a procedural. Just on the procedural side of it, and I hope we can revisit it next month.
No, this outline would like to testify, and then I'm going to go to you, Tom.
Are you open to having me speak?
Absolutely, you're
Okay. Thank you. So one of the things that was part of the judicial branch salary presentation by Jeff Shorbaugh was that they didn't want to negotiate against themselves. And I kind of feel like that's what I'm hearing here. When we're trying to guess what the legislature will do, we're really negotiating against ourselves and reducing the amount that we're asking for. I think we should be realistic for what we think that the judicial branch needs rather than asking for what we for. And I would vote against the 6 and 6. So just wanted to throw that in there. Thank you.
We have, Tom.
Just to clarify my earlier comments, I had asked to clarify whether or not the fix could be taken up as a separate motion, and I think confirmed it can. I wanted to be clear, while I very much support the Minnesota District Judges Association and their proposal, we were called upon to evaluate that, I heard earlier today. And based on what I heard earlier today, I am more convinced that the Judicial Council's proposal of 10-4 is the one that we should support and recommend. I also appreciate Jim's point. If there is no harm in waiting until we meet next to make a formal decision on this, I think we should. But if I had to vote today, I would vote in favor of the 10-4 recommendation.
Last comment to the Boston motion.
Thank you. Mr. Chair,
I'm sorry. I need to, go ahead, Amanda, and then we'll.
Procedural question, could we do a conditional vote to have, or authorize or vote to have the chair and co-chair write something up and then we can officially approve it next time? It was my understanding that's what we had envisioned it needs to be.
Technically, we have a motion from the body, which we need to either vote on or have withdrawn. And so procedurally, we're gonna move forward on a motion in front of the body. Until.
Yeah, I think what you're asking is could we traditionally will vote for a proposal, adopt it, and then we'll write something up that we would all agree on. I think, is that what you're suggesting?
Yeah.
Yeah, that's what we would do.
Okay. Yeah, that's our
I think in
goal.
the past. Yeah, well, let me just respond to three things. One, on the timing, we don't have to do it today. We could delay it and do it in August. I guess I do somewhat disagree respectfully with the idea that we're on such a short time frame for such large information. From my perspective, a lot of the information we've heard and seen is stuff that we've done before. We've seen that we've heard from the same folks, read the same things. There isn't a huge volume of new material that we need to see, and I'm not seeing a lot of things that are different. I mean, Professor Banyan gave the same presentations previously. So I'm seeing a lot of the same information. I feel prepared to vote and decide on this today. I think that also gives us an opportunity next month to devote a meeting to thinking about what we might need for next year, where there's a bigger task ahead. And when that happens, I mean, some of us might not be here for that council. There will be new people for that council, almost certainly. That's the type of preparation that I've heard from this group that we need to do. And that's what I was hoping to devote August to. We could devote it to hearing from the same thing again, here we've heard today, and having the same conversations. I suggested, because I think the evidence all supports towards particular numbers, that we could vote on that today, get that done and use the next meeting for something different. So that's the basis for the timing, and I think that makes sense.
My apologies to I'm gonna go back to a minute. I skipped over one person online, so I'm gonna give Amanda the floor, then I'm gonna go back to you.
Okay, great. Yeah.
Go ahead, Amanda.
No, that's basically exactly what I was going to say. And also, we're assuming if we have a vote today, that we're also going to have a proposal that passes. So I think we need to vote. If we have a proposal that passes, we still have the next meeting to finish up the housekeeping items we have. If it doesn't, then we still have the next meeting to continue with the additional information that we need. But I do think I agree with the last speaker that I think I'm prepared to move forward with a vote, and I think that is the right path forward.
Final comments from the author of the motion.
Yeah. The last thing I want to talk about was this idea of negotiating against ourselves, which is a term I don't think is that helpful, and especially not in this context, because we're not negotiating. Our job isn't to go back and forth with the legislature about what they would accept, and we would never try to do that. Our job is to study, hear about the information that's presented, and then make the best recommendation that we can. I think that's what this motion does, because I think we have heard from the academics who've studied the issue. We've looked at the information we had last time and heard from the Judicial Council, and come in at a number that's basically the same thing as we decided a year ago. So I guess I just don't view it as our own negotiating tool. Maybe someone else would use it for that purpose, but I haven't seen that being the way it's been used either. That's all I have to say.
You do a roll call on motions, from across the board. So the clerk will take the roll.
Chair McCormick,
Aye.
Vice Chair Ask,
Aye.
Gary Borgendall,
Yes.
Tom Boyd,
Nay.
Yes, Grant. Devin Driscoll,
Pass.
Ben Gerber,
Yes.
Adam Hansen,
Aye.
Susan Holden,
No,
Roger Josephson,
No.
Amanda Matchett,
No.
Amanda Mills. Nay. Nick Morgan,
Aye.
Carl Morton Badger,
Aye.
Amber Not. Betsy O'Berry,
No.
Jim Robbins,
No.
Christy Schmidt,
Aye.
Tim Stout,
Aye.
and Whitney.
No. Oh, pass again.
Oh, Devin Driscoll.
Nay.
Vote being 9-9, the motion does not pass.
Bring them on.
I'm most, it's probably the same one that you put go for, Mr. Boyd.
Amanda, Devin, and Tom. I left to, right, just to change up. Amanda,
Oh.
Devin, Tom.
All right, I move to recommend the legislature increase salaries of 10%, judicial salaries 10% on July 1st, 2027, and 4% July 1st, 2028.
Motion before the body is, as stated. Discussion.
Second?
Second, sorry. We don't second things in the legislative process, so I have to remind it that we do it here. So, thank you for the second. Discussion.
So, point of clarification, which has already been clarified, just to make sure that a vote in favor of this motion would not preclude further discussion either today or possibly at the next meeting of a fix.
And typically, as a vote in favor of this motion would then result in the vice chair and I coming up with language that eventually would be in a report. And then other motions could be made. Deem the motion adopted, for that, we do that in a kind of advantage motion, or separate additional ideas. And adjustments, which would either made today or at the August meeting.
Okay.
Further questions, comments?
Members, I think this is the numbers you're talking about from Professor Banion's report on referring to it as 6 and 6 and a fix, starting with the 219,169. And so those would be a 15% increase in the first year and a 3% in the second year. So if members wanted to just directly make that motion, I've added here, so you can review it.
Motion in front of the body is a 10% increase and July 1, 2027, and a 4% increase on July 1, 2028. Comments?
The follow-up question on that information from Professor Banion. Is that just the Banion information, or was that a translation of Minnesota District Judges? Which I thought was 6 and 6.
That was just, Professor Banion provided 4 different proposals. And that is his first proposal, which he referred to as Restore Compensation Council 6% plus 6% recommendation. I believe he had presumed that the last recommendation had been made and then made a recommendation upon it. And so that's where the 6 and 6 comes from.
My recollection is that Professor Banion didn't make a recommendation himself, and it was the District Court Judges Association who did. I noticed that Judge Kyle is here. And so I wonder, Judge Kyle, if you would mind confirming that the 6 and 6, the plus fix is the preferred option of the Judicial Council.
I think this is like a Woody Allen movie. There's something,
Could you come to the table? Have a record of the tape.
So Dr. Banion's recommendations And the District Judges Association, different. So it's like our recommendation, MDGA's recommendation for 6 and 6 is just starting 6% from 190, which is the current, and another one for 6%, the second year of biennium. Banyan has various proposals. When he talks about 6 and 6, he's talking about restoring, he's taking into account inflation the last 2 years, not getting that 6 and 6, getting zeroed out. So ours is a pure 6 and 6 start with what we have right now. He's looking at 6.6%, 6 and 6%, assuming the judges have gotten what they had gotten before.
Oh.
Okay, so it's a higher number. His is a higher number.
So this, if you could look at the screen, Judge Cal, this 15%, 3%, which looking at the handout from Christopher Banyan is his standard number one. That's your understanding of what he was recommending.
Yes.
Okay,
Yes.
but ours is different, is 6 and 6, just straight, just the thing that just tied.
Yep.
Okay.
With what the legislature did we start, about 96% on top of that. His was different.
And apologies for our confusion, the headline of your slide is 6 and 6 plus a fix, so that's why we were confused.
Right. And the fix is not a percentage increase, that's a statutory request change. That's a different situation.
Got it, thank you, Judge.
We're in the middle of a motion, so to the motion.
Just one comment, while not trying to guess how the legislature would react to any specific proposal. I think the likelihood of it's marginally increased by having the same number. In the sense that they're gonna do the lifting on this. To have to always explain that the compensation council had a different number that was close, but why did they do it that way, et cetera? If we in fact believe that the range between 12 and 14 is not that large, I think tactically it would be far smarter to have it, have our recommendation to align with the people who are gonna do the lobbying of the legislation.
Proposing an amendment to 7.5 and 4.
Amendment is offered. Changes from 10% in the first year and 4 in the second to 7.5% in the first year and 4 in the second. You have that amendment and those changes. That they're to the group. Discussion on the amendment to the amendment.
Is there a second?
Is there a second to the amendment to the amendment? No second. So we're back to the motion. I see the question. See no further comments. The clerk will take the roll.
Chair McCormick,
Yes.
Vice Chair Ask,
Yes.
Gary Borgendell,
Yes.
Tom Boyd,
Aye.
Stephen Driscoll,
Pass.
Ben Gerber,
Aye.
Adam Hansen,
Aye.
Susan Holden,
Yes.
Roger Josephson,
Aye.
Amanda Matchett,
Yes.
Amanda Mills. Yes. Dick Morgan,
Yes.
Carl Horn Badger,
Aye.
Betsy O'Berry.
Uh.
Betsy, can you repeat that?
Aye, yes.
Jim Robbins,
Aye.
Christy Schmidt,
Aye.
Tim Stout,
Aye.
Ben Zimmerman,
Aye.
Devin Driscoll,
Aye.
Vote being 18-0, the motion carries. We will be coming back in August. There are other motions in the judicial area at this point, you can entertain them. Or I can move to the OIG matter, and if we have time at the end of today's meeting, we can entertain more motions on the judicial matter. So, without objection, I'm about to move to the OIG testimony, which, I don't know
I don't know if this is appropriate procedurally. insofar as this committee may, or this council may pick up, discussion of a fix as proposed by the association, at this meeting. Whether or not it may be possible to have, language developed, it looks as though there may have been some language in this draft here. And if we could get input, unless we already have, input from the Minnesota District Judges Association, whether or not that's language that would accomplish the fix they have in mind.
Apology, Tom. I was gonna move to that language next.
Okay.
So, and Vice Chair Ask is gonna make a motion and see it as item number 3.
Sure, I'll move the item number 3, which is to include the following language in our report. The council recommends the legislature establish statutory methods of automatic adoption of funding of the compensation council's judicial salary recommendations consistent with the legislature's constitutional obligations to prescribe the compensation for judges.
You had called for testimony on that. Is there a testimony that anybody would like to offer here? That, well,
Was that offered as, were you just reading it or was that offered as a motion?
That was a motion.
Okay.
that motion is before us, discussion.
I second.
Second. Thank you, David.
Can I speak?
Always remind me of that because somebody has to. Go ahead.
Sure, I believe this is the fix, right? Yeah, this is
A variation.
it was a variation of the fix. It's intended to recommend an ongoing, essentially prevent the situation we're in where there's 0 and then huge attempts to get 10% or more back, which is a challenge. So it also recognizes a comment that came up last time about the constitutional obligation of the legislature to prescribe compensation for judges, recognizing that exists and that any proposal would be consistent with that. So.
I just have a question again from those, or for those who are wise and experienced. I strongly support this motion. And my question is coupling or recommending the motion for the action that we've just passed with the last motion, but also recommending this fix if it's approved by the council. Is that constructive in the overall goal to obtain judicial increases, or would it be a distraction for the legislature? And would it be counterproductive in terms of obtaining the 10% and the 4% increases?
Much for anybody? I mean, I can just say that it depends. You have 1 new members of the legislature. You could draft this as 2 separate questions within a piece of legislation. You could say, here's the 10 and 4. And going forward, effective the next compensation council, their recommendations will have the following impact, and then their attorneys can figure out different ways they believe it's constitutional to empower this compensation council. And that would be this presented in 2 different ways. Or you could say, we just simply ratify now and going forward all recommendations. And it depends on how the bill is drafted. Devin.
Obviously I seconded it. I agree with the proposal. I particularly appreciate the acknowledgement that we got to figure out what the constitutional issue is and get through it, which is great. I think that we could, to address what Chair McCormick just mentioned, we could recommend that the next council, who won't be voting on judicial salaries, right, next year, they'll be working on the executive branch salaries, that they make this recommendation, if that makes sense, to separate it from our recommendation of judicial salaries now, because that's going off during this budget process that's happening. And then next year, early on, the council in its deliberations in February or March could make this recommendation, and it sort of doesn't muddle the 2 together then. The policy recommendation separate from the salary recommendation.
And to do that, you would say the compensation council recommends that the legislature, that effective for the 2027, 2028 compensation council, the legislature establish.
Yes, in going forward.
Yeah, that's,
And we could incorporate that.
yeah, that's okay.
We're gonna, that'll be incorporated, and if this goes forward today, we will come back with language of how we would implement the report. So the incorporated change would be Compensation Council recommends that effective for the 2027, 2028 Compensation Council, the legislature is established. And on, that's the statement. Jim.
Okay, so we add this. It has no impact until when the next compensation council meets. It has no effect whatsoever, other than it's our opinion. And I was able to listen to the judicial council's reaction last month. And they thought I'm just going to give you a general response, because, oh, that's interesting. The NDJA is proposing that. I didn't hear, wow, let's get behind that. But maybe it was discussed today, or maybe it was not discussed today at the judicial council. I understand why would have access, because they weren't in the usual meeting spot. But for us to act on this with having just so little input, and the judicial council really is governing body. I'm not disparaging the MDJA, but they are a constituent of the judicial council. The judicial council is, it's the ball. And why are we doing this now? I just don't understand why we would do this now. Let the next council deal with it, please.
Tom? Oh, sorry, David.
Well, I would like to respond to that. I mean, we often put things in the report that aren't directly impacted by the recommendations of the report. We say this is something that we think you should study. This is a huge issue. I mean, I don't know how you go in and argue for 10% in the budget environment we're in, but that's what's going to happen. So we'll go and argue for that. So I assume they'll point out that there's a structural problem with how we're dealing with salaries in this area. And so I think it would make sense and support that position to say, we think you should address that structural problem. I don't think that I would need to hear what other groups think about that, just having served on this council, to say if we can make that recommendation.
Briefly, I agree with that. I think that the present motion is embodied or reflected in the 10%. That demonstrates the need to pass the 10% increase and to pass the fix so that we avoid this.
That's the phase.
Okay, and Amanda online, you have a comment or question?
Yeah, no, that was, I mean, once again, I think that's pretty consistent. This is my 4th term as well. And it's like I joined this to take the, responsibility for those decisions and try to make those decisions and do the best job that we can do with what we know now and not kick it to the next group. We've also seen that our recommendations aren't always taken, but I think we need to make the recommendations that we think are best and the most productive and are needed today as our council. I think I have enough information for us to do that. If others don't, I totally respect that as well. But I'm supportive of, obviously I voted for the 10 and 4, and I'm supportive of a fix as well too, because we're here to solve those problems, get those solutions, and take responsibility as part of this council. So I'm supportive of that.
Betsy? Betsy, did you want to question our comment?
Yes. Sorry, I didn't hear you. I agree with Amanda, but I also would like to make sure that when we are voting, could you please restate the question? The last few times we voted, and we've kind of gone back and forth on some things. We've had some potential amendments. I think it's really important that we make sure that we all know exactly what it is we're voting on. So just a request that when we call for a vote, the motion is restated. Thank you.
The motion is to adopt 2026 Compensation Council report. This phrase, Compensation Council recommends that the, if you have the language as we amended it, I would have you read it out loud as a clerk.
Apologies if I didn't get it correct, but we would add to the Compensation Council's 2026 report. The Compensation Council recommends that effective for the 2027 and 2028 Compensation Council, the legislature establish statutory methods of automatic adoption and funding of the Compensation Council's judicial salary recommendations consistent with the legislature's constitutional obligation to prescribe the compensation for judges.
Comments from Gary.
Just a question, does it need ongoing in there or is that stated because they do that and that carries
I think
forward?
that's implicit.
Okay, it's fine, thank you.
But we'll examine that question offline and bring it back next time if we feel like we need that phrase. Final comments from David? No, okay, sorry. Carl?
Thank you, Mr. Chair. I'll be a no vote on this, and I think I just thought I'd take a second to explain why. I do think one point is it is a little bit distracting, but I think at a broader policy level, maybe I'm the one here, but I'm a little skeptical of, automatic delegation of with funding to, an extra kind of quasi legislative body. I obviously understand that the legislature can override under this proposal any sort of funding recommendations the council would make, just like it can be done for executive officers, but admittedly, on a personal level, I'm not sure the executive branch salary should be handled a little way we currently handle judicial branch salaries. That is maybe me putting on my legislative hat a little more than my compensation council hat. But I think since we're kind of veering into policy that the legislature would have to adopt, I think it's a little more appropriate to put on that hat here. So I'll be a no on this.
Final comments from the author of the motion? No final comments? Clerk will take the roll.
Chair McCormick.
Aye.
Vice Chair Ask.
Yes.
Gary Morgenthau.
Yes.
Tom Boyd.
Aye.
Devin Driscoll.
Yes.
Ben Gerber.
Yes.
Adam Hansen.
Yes.
Susan Holden.
Yes.
Roger Josephson.
No.
Amanda Matchett.
Yes.
Amanda Mills. Yes. Nick Morgan.
Yes.
Ron Morton Badger.
Nay.
Betsy O'Berry.
Yes.
Jim Robbins.
No.
Christy Schmidt.
Yes.
Tim Stout.
Yes.
Devin Driscoll.
Aye.
There being 14 ayes, 3 nays, the motion carries. Next up on our agenda today is some comments and discussion on the OIG, Office of Inspector General salary. Nick is going to provide an overview. And there's a whole series of documents in your package.
Yeah, members, I know my paperwork is all a mix now, but in your packets, is some data, that was requested about the OIG. So that includes, comparisons to, IGs from other, state agencies within those state agencies. And then also, the head of the Medicaid fraud unit in the Attorney General's office. I think that is it. Oh, there's also some position descriptions that MMB provided for those inspector generals within those state agencies. I'm happy to answer any questions, and Dory from MMB is here as well.
Dory, could you come to the table?
Sure. So between the two of us, hopefully we can answer any questions, and if there's additional data that we didn't provide, of course, let us know.
Dory, why don't you state their name for the
The director of the workforce development.
and then finally, eventually we're gonna have a motion from us that is, sorry, 198-214. You remind us where that came from.
the recommendation is based on an evaluation of the complexity of the job as done through the job evaluation study called the A method. It's consistent with how other jobs in the executive branch with a similar number of whites are paid. It's also more or less consistent with how other agency heads and agencies of similar size are paid. And of course, those salaries have been set by you as well, and so they're kind of consistent with how other agency head salaries have been established.
Any discussion, Jack?
I just want to get a clarification from Ms. Leland. I really appreciate your work. I particularly thought we benefited, well, we didn't use it, we benefited from being provided a hay card last year. And I'm glad that the chair is supporting the case study. I think that's a very difficult thing for you to do between now and next year. But I guess my question is, on the recommendation based on hay, it's actually modified hay, I believe. Pay range you have is 28M, is that correct? And it's the top of that range, is that correct? Yes, correct. Thank you.
Just on that point, that last time I suggested that Constitution Council was for the development of a hay study or modified hay study for most of the cities, it's ours next year. That's something we should put in our report. Or just us talking, telling you now, Stan, if you're supposed to that in place.
There would be a cost. We could internally manage doing the one evaluation for the inspector general, but most of my trained evaluators are busy doing job evaluations for the fraud evaluation classifications, and so we would need to outsource it, and there would be a cost of between probably $50,000 and $100,000 to do it. So I can't commit, and I need to be able to front that cost.
Other questions for any of the testifiers? Votes online. Tim?
So I want everyone to comment, but I want to address, I assume it's Nick's chart that he put together with the Inspector General, the Legislative Auditor, and actually Director, the AG Director. So, control unit, just, I'm gonna call this to project. I'm gonna let everyone and have the conversation that I'm going to have. I'm going to have a thought process that I'm going to provide you. No one.
Here, no other comments or questions?
All right, so here it is. First of all, keep in mind that the governor be in charge of having a recommendation to follow up after all of the work of the Legislative Joint Advisory Commission. It's a lot of process to be done here. It's not a department that exists at the moment. So let's just take a look. To me, it looks like the AG's assistant attorney general is the director of the fraud control unit, is the most similar comparison point. And that pay range, AGM3 pay range, is 128,000 to 195,000. That person in that position is in its 11th year in that position, has extensive private and county prosecutorial experience. There's virtually no question that he is very capable, as evidenced by the legislature increasing the staffing, 18 positions. So let's talk about how that compares to the inspector general. That pay range is 138.5. I'll take it back. Yes, 138.5 to 198.2, so slightly larger. I think that's a very good assessment. However, the proposal is to put that salary at the max. The AG assistant general, that's assistant general, is at, as of January 15th, was at 173,800. I'm going to guess that person got an increase of 6,000 or 8,000. I don't know. That's not publicly disclosed at this point. But put that pay point at that maximum amount of the pay range of 198 puts the governor in a difficult position if he or she decides this needs to fit into all of my different positions in the transition. So, I mean, when you look at the human rights, which is currently the smallest department, 55 FTE, that pay level is the 189,026 reference, least amount that Ms. Leland had posed. Now, after we do all this work, I mean, the LCC does all of this work. Next year, there'll be a clearer view. This is a temporary salary setting. We can always go higher. No governor in their right mind is going to come back and say, you set this too high. This person will not be in the position until the Fed next year. This next council is going to be recommending for a few months later, the full biennial. Why? I just think we should look at setting it a little bit lower. 189,026, I think, would be fine. Would give a little leeway in pay range. It gives the governor, whoever that person may be, more flexibility. No, it's not a motion. It's explaining why I think.
I go with Tom and then Susan.
I appreciate your observations, Jim. When I think about this, I think of this for what it is, which is very undertaking. Also, I recall from our last meeting, there are fairly impressive credentials that are required, for lack of a better word. So it's clear the legislature is lucky to have a highly qualified person come in here and to pretty much build this out and implement the statute and address one of the most important things that, at least publicly, the state uses. So I can't quantify it, but if I were to err, I would err on the high side rather than looking at this as routine, but a straightforward human resources decision. And I think it would be wise for this council and wise for this state to err on the high side and offer a higher salary in order to have a very competitive and well-qualified pool for the governor to choose from. So that's how I come up. I'm going to err on my high side.
Yeah, Susan, and then online we have Amanda.
I had a similar impression when I looked at this chart that Jim, you were referring to and that we've all had the benefit of reviewing. Is that, you know, when you look at the position in the AG's office, that's a very narrow position. The kinds of requirements and credentials and breadth of operation, supervision is necessary for this new inspector general position. And I was looking for the salary to be beyond that 195 point for the manager of the Medicaid fraud control unit, which I view as a much narrower position that requires essentially prosecutorial experience, but not a lot more. So I'm in favor of being in the high side as recommended by management.
Amanda, followed by Devin.
Yeah, I agree, especially if this is a new role. You know, this isn't a role we want someone who's new to this or maybe is stretching into. We're going to want someone really experienced, really qualified, really good to step into this as they're building out this program. And so that's going to probably need a significant or a more significant investment to make sure that we get those qualified folks. So I tend to agree with the group that we'll want to look on the high end, but especially being a new role that you're building out, experienced people who would be interested in that are going to recognize how difficult that's going to be, and we're going to have to compensate accordingly.
Absolutely agree with Susan's point about the attorney general comparator not really being one that makes sense for me, given the more prosecutorial nature of that, but also this is not our ambit, but I'll just note that the attorneys in the Minnesota Attorney General's office are so underpaid, we should be ashamed of it. And so the idea of using that as a baseline for me is just something I'm not
David's gonna read the motion. Yeah.
I'll move to set the inspector general salary at $198,214 as recommended by MFB.
Second.
Motion is made and seconded. Discussion.
I'll just speak to it if I could. I mean, I think this is also a situation where, based on what we heard the last meeting, everything was pointing toward this number. Sometimes I feel like in these meetings, we're sort of just thinking of numbers, and it seems high and it seems low, and it can be, because sometimes it doesn't, I'm not gonna say it feels arbitrary, but it doesn't feel as clearly defined as this one, where the comparative positions, the studies, and then the requirements, the qualifications for the position all seem to support this type of a number. I appreciate that it is at the high end of the range. I think that's okay, given how important this position is. So I would urge vote supporting this motion.
You got a second?
Yeah.
Jerry McCormick,
Aye.
Vice Chair Ash,
Yes.
Gary Borgata,
Yes.
Tom Boyd,
Aye.
Brent, Kevin Driscoll,
Pass.
Ben Gerber,
Aye.
Adam Hansen,
Aye.
Susan Holden, Roger Josephson,
Aye.
Amanda Matchett,
Yes.
Amanda Mills. Aye. Dick Morgan,
Yes.
Paul Martin Badger,
Aye.
Betsy O'Berry,
Aye.
Tim Robbins,
No.
Christy Schmidt,
Aye.
Tim Stout,
Aye.
Devin Driscoll,
Aye.
Fifteen ayes and one nay, the motion is carried. Last item on our agenda for today is a discussion in general and about future meetings. In August, we will be meeting on August 20th. Focus of the August 20th meeting is discussion of what we would like this council to have in hand when they are seated in January, February of 2027. So first of all, I'm gonna make sure that have Emma be online. Buyers of data, you will be there on the 5th of August. So if you have ideas of what specific data you would like, other than our usual data early. And in addition to what I've talked about, a haze or modified haze to the extent practical. For the 27th, send that to me and to David and to Nick, and we're gonna put together testifiers, and we're gonna have an open-ended discussion. To the extent that we can, we're gonna try to have a report and motions about adoption of the report that we usually do. I should have a look at that. Ready? Well, I mean, this is just to get the report drafted. No, we don't need to do that. He's ready, we'll do that next time. So thoughts, discussion prior to the next meeting, anything you'd like to see there? Stay tuned for agenda, next meeting, that we'll talk about these things. We're meeting here, probably in this room potentially, from 1 to 4, or as long as we need to, on August 20th. And with that, the committee meeting is adjourned.
Good work, chair, assistant chair, vice chair.
Well, I thought you on the
Yes. Well, see you, maybe.
Yep. Thank you.